Meine sehr verehrten Damen und Herren, wir sind wahrscheinlich noch nicht ganz komplett, aber wir haben eine Angewohnheit, dass wir ungefähr zwischen 18:07 Uhr und 18:09 Uhr genau unsere Veranstaltung beginnen, weil wir eben zwischen Sine und Cum tempore agieren und dann ist der Zeitpunkt nicht so genau zu fixieren. Wir freuen uns, dass auch unser Artist in Residence der Spur und den Spuren der Ästhetik sogar im Bereich des Verfahrensrechts, wo man es am letzten überhaupt vermuten würde, sich nicht entziehen möchte, weil wir heute einen ganz besonderen Anlass haben, nämlich Inge Kroppenberg begrüßen zu dürfen, nicht nur als Fellow, wo sie schon seit längerem tätig und aktiv ist und sich auffallend und auffällig bemerkbar gemacht hat mit ihren Überlegungen und mit ihren Ansätzen, sondern heute auch zu ihrem Forschungsthema sprechen wird, nämlich, and I will switch into English if you agree, because some among this nice crowd are not completely familiar with a German language. The art of procedure, logic and ethics of the development of law in modernity. This is an interesting title, not only because it's about ethics and the law, but because the notion of development is put in the center of the debate. We'll see it later on if this suggestion is right. Inge Kroppenberg studied law in Mainz, as some of us. She obtained her doctorate degree there in 2000 and completed her habilitation in 2005. And then it goes on with professorships in Leipzig and Frankfurt. From 2007, a chair in private law, Roman legal history and modern private law history at the University of Regensburg's Faculty of Law. And then since 2013, leaving Bavaria, we don't know exactly why. Some of us might have some ideas about that. To hold the chair for Roman law, private law, and modern private law history at the University of Göttingen's Faculty of Law. By the way, the law that gave me, the faculty, my law degree, the doctorate degree. So we have even something in common. Where she had the Department for Roman Law and Jus Commune at the Institute for Legal History, Philosophy of Law, and Comparative Law. So most of you have had the occasion to learn what her research interests are. It is family law, we heard about that, estate law, as well as cultural history of law. What this exactly means, Kulturgeschichte des Rechts und nicht Rechtsgeschichte des Rechts oder des Kulturrechts oder der Rechtskulturen, sondern Kulturgeschichte des Rechts. I suppose that you voluntarily have made this choice, and you will explain it to us certainly during today or at another occasion. I would be very keen to know where and how you came just to this kind of formulation, and it is not a contingent formulation. Then, since October, Professor Kroppenberg is fellow at our center. So for those who wish to experience the elegance of civil law argumentation close to the original text, her habilitation treatise Privatautonomie, sorry, it's this one, von Todes wegen, so rather difficult to translate. You might certainly do that, Miss Grant, who is a newly arrived fellow at our center and familiar with this much too much difficult language, or this difficult English, roughly translated as testamentary private party autonomy. That's completely wrong, but so es geht Privatautonomie von Todes wegen, published with Mohr Siebeck. The work emphasizes the independent character of testamentary freedom in terms of party autonomy in a manner reminiscent of Werner Flume's praises of private party autonomy. If that is right, that was my reading of this book. Perhaps I'm completely wrong, and you will explain that. So, but I was a student of it, that's why I recognized and I smelled the Flume argumentation in the book. In the case of insolvency, the relationship between creditor and debtor comes to a head. What classical Roman law made of this and how it has been defended against prominent legal historical opinions can be found in the dissertation Die Insolvenz im klassischen römischen Recht, Tatbestände und Wirkungen außerhalb des Konkursverfahrens. I have to recommend both of the books. But this is not absolutely what you have done also for the law and literature, law and art debate. There are very remarkable contributions that you have made. For example, the last one that I've seen is a video podcast of your Antrittsvorlesung Die Plastik des Rechts, Recht und Sammlung bei Rudolf von Jhering. So you will find it on our website, and I think it will be very interesting for you to do this. I did not plan to talk too much about the content, especially as I don't know the content in advance. In France, you can meet researchers to whom you just have to tell the title of their talk, at least after they have done and held the talk. In this case, I won't do it the other way around by telling what you will tell us, especially if it is about storytelling. It would be a very bad story to tell what you will tell in a way that I can't tell you at all. So the floor is yours. Thank you very much for being with us. All of us will take notes and we'll ask very difficult questions. I promise you. Okay? Thank you very much for being with us.
Lieber Herr Gebhardt, vielen Dank für die freundliche Vorstellung. Ich bin mir gar nicht bewusst, dass ich mich so auffällig eingebracht habe bisher, aber naja, gut. Dear co-fellows, ladies and gentlemen, what I will do tonight is divided into two parts. First part of the lecture, I will give you or talk about the notions of my projects, basically based on the paper I handed in. And then in the second part of the lecture, I want to go further and share some thoughts about perspectives of the projects. I called them fields of interest. I want to pursue in the following year. So the second part of the lecture is actually especially designed for today and is something new. Schreiben von und über Recht folgt oft einem bestimmten Muster. Bevor die rechtswissenschaftliche Auseinandersetzung mit dem eigentlichen Gegenstand begonnen werden kann, muss zunächst seine Geschichte gebändigt werden. Ebenso in Urteilstexten. Auch hier können die rechtlichen Erörterungen offenbar erst beginnen, wenn die tatsächlichen und prozessgeschichtlichen Fakten richtig dargelegt und unverrückbar festgestellt worden sind. Auch mein eigenes Fach, die Rechtsgeschichte, wird heute oft so betrieben, dass der Sinn der Geschichte und ihre Bedeutung für die Gegenwart aus der Ereignisfolge selber deutlich wird, ihr gleichsam abgelesen werden kann, wie man im Standardwerk zum Historismus von Jäger-Rüsen lesen kann. Juristen, meine Damen und Herren, so scheint es, schreiben bevorzugt Entwicklungsgeschichte oder Entwicklungsgeschichten. Während sich das Entwicklungsdenken als narrativer Generalschlüssel in der Geschichtswissenschaft und anderswo nach der Auffassung des Konstanzer Literaturwissenschaftlers Albrecht Koschorke als in seiner, Zitat, Partikularität immer fremdartiger werdendes historisches Erzeugnis erweist, Zitat Ende, bleibt juristisches Schreiben und Denken von ihm bis auf den heutigen Tag maßgeblich geprägt und beeinflusst. Sind Juristen also geborene Historisten? This observation, ladies and gentlemen, is the starting point of my endeavors. The structural similarities between European forms of legal procedure originating in medieval canon law and the modern narrative of development, Entwicklung, which ever since the long 19th century has become a key concept of Western knowledge, informing whole areas of thinking and the arts in the process. A narratologist analysis of the historicist notion of development, which was also an important feature of legal science, Rechtswissenschaft at the time, might not only reconstruct the aesthetic functional relations between narrative and legal procedure, but also elucidate the judicial foundations of the narrative grammar of modernity, the Erzählgrammatik der Moderne, as it is aptly named by Albrecht Koschorke again. Such an analysis might further explain why legal scholarship in Germany, as well as abroad, still, in my view, prefers neo-historicist schools of thought to approaches originating in the social sciences and in cultural studies. During the coming months, I would like to work out the foundations of an aesthetics of law, looking at the concept of development as a particular part of European culture instead of something timeless and universal. Based on this, I would also like to discuss alternative forms and techniques of procedure. Let me, ladies and gentlemen, present my ideas in the following 5 chapters. So we've got 6 here, but we are already at the end of this first, so it's just 5 more to go. Vergleiche rechtlicher Verfahren mit fiktionalen Texten gehören, meine Damen und Herren, zu den bevorzugten Betätigungsfeldern der Law and Literature Bewegung. In jüngerer Zeit wird allerdings vermehrt Kritik an den überkommenen Ansätzen Law as Literature, Law in Literature geübt. Besonders angezweifelt wird ihre Tauglichkeit zur juristischen Analyse, zu der ihr das passende Instrumentarium jenseits der Untersuchung literarischer Rechtsallegorien oder mechanischer Kausalitäten zwischen Kunst und Recht zu fehlen scheint. What it might better do, I believe, so der amerikanische Literaturwissenschaftler Peter Brooks, is to demonstrate to legal studies that it has analytic instruments in its toolkit that might actually be of some use with the legal plumbing. Quote end. Deshalb interessiere ich mich, anstatt die Literatur, für die wissenschaftliche Dekonstruktion dogmatischer Montagen oder, das ist noch ein Zitat von Brooks, cozy humanizing teddy bear for law to curl up with, in Dienst zu nehmen, für strukturelle Homologien, denen ich mich mit den Mitteln der Erzähltheorie annähern möchte. Zu meinen Grundannahmen gehört dabei, dass Verfahren von Geschichten informiert werden, aber als solche auch Geschichten sind und dies in Widerspruch zu Grundüberzeugungen einer Rechtssoziologie, die das erzählte Recht für endgültig überwunden erklärt hat und auf der grundsätzlichen Unvereinbarkeit von moderner juridischer Rationalität mit Narrativität besteht. Narrative, so Albrecht Koschorke, sind erzählerische Generalisierungen deren innere Struktur darauf gerichtet ist, die Welt zu modellieren und die an ihr Beteiligten darin zu verstricken. Sie bedienen sich dazu einer Anzahl von Grundtechniken. Aus einer unüberschaubaren Menge von Elementen wird eine relativ kleine Anzahl ausgewählt, Reduction, und in der Erzählung operationalisiert. Das heißt, es wird eine semantische Struktur etabliert, die einem bestimmten Muster folgt. Pattern Formation, Schemabildung. Dieses wird in der Erzählung zugleich bestätigt und variiert. Redundancy and Variation, Redundanz und Variation, wodurch ein offener Sinnhorizont entsteht, der auch Neuansätze oder Neueinsätze oder alternative Erzählungen erlaubt. This is called Diversification. Narrative sind rekursiv angelegt und modellieren Zeit in Sequenzen. Formation of Sequences, Sequenzierung, die Erklärungszusammenhänge erzeugen im besten Fall. Das ist die Motivation, Motivation. Narrative installieren Erzählinstanzen, die über Inklusion und Exklusion von Personal- und Sachthemen entscheiden. It's very central to legal procedure, positioning of the narrator. Who is the narrator anyhow in legal procedure? Gleichzeitig regulieren sie psychosoziale Dynamik, Erregung und Bindung von Affekten. Ich habe das hier als affective regulation übersetzt. One of the most powerful metaphors a narrative can use is the concept of development. Creating a temporal order of strict sequentiality, it establishes a factual logic according to which things may be presented in an objective way. For the story as a whole, as well for each one involved in it, development provides an understandable, coherent narrative and a believable outcome. Thus, by presenting history as a steady flow of events, even radical change, revolution, is made legitimate and acceptable. Often, it is connected with the concept of progress, Fortschritt. It tells us to learn from history because whoever learns will be well prepared for the eventualities an uncertain future holds for him. Auf Entwicklungslogik, meine Damen und Herren, stützt sich auch das Narrativ des Gerichtsverfahrens. Bei diesem handelt es sich nach der klassischen Definition Niklas Luhmanns um ein soziales System, das, Zitat, eine spezifische Funktion erfüllt, nämlich eine einmalige, verbindliche Entscheidung zu erarbeiten und dadurch von vornherein in seiner Dauer begrenzt ist. Zitat Ende. Das setzt Strukturbildung, Episodisierung, Zielmarkierung, temporale Differenzierung, das sind Luhmannsche Begriffsbildungen voraus, mit der Weltkomplexität reduziert und Kontingenz bewältigt werden kann. Den narrativen Merkmalen von Reduktion, Reduction, Redundancy, Variation und Diversification, so diesen Merkmalen entspricht bei Luhmann die Operation der Ausdifferenzierung des Verfahrens als selbstständigem Handlungssystem. Seine Eigengesetzlichkeit, die sich etwa in autonomer Zeitstruktur und Unterteilung in Verfahrensabschnitte ausdrückt, entspricht die narrative Sequenzierung. Narrative Schemata wiederum finden ihre funktionalen Äquivalente in den Programmstrukturen unterschiedlicher Verfahrenstypen, wie etwa dem Straf- oder dem Zivilprozess. Motiviert wird das Verfahren auch darin narrativen Gesetzmäßigkeiten folgend, durch die anhaltende Unsicherheit darüber, wie die Geschichte wohl ausgehen wird. Und ebenso wie die Erzählung verfügt auch das Verfahren über ein Publikum, das affektiv erregt und gebunden wird. Hier sind die Stichworte Glaubwürdigkeit und überzeugende Inszenierung. So wird vielleicht überraschenderweise selbst bei Luhmann recht dramaturgisch erzeugt, nämlich in einem, Zitat Luhmann, Drama, das richtige und gerechte Entscheidungen symbolisiert, eben dem Verfahren. The most important parallel between the narrative of development and modern legal procedure is the place where the narrator, decider, is located. He's located out of sight of the parties and the public at large. However, for both narrative and procedure to succeed, the strategic removal of its pivotal figure is not necessary. Historically, narrators and judges have often been placed within sight. As regal adjudicators, Christus Pantocrator comes to mind, or symbolized through ordeals or trials by battle. Due to their open subjectivity, however, such arrangements lack credibility and legitimacy. As means of production of truth, they are considered as neither powerful nor efficient enough. Since it is, as we are reminded by Albrecht Koschorke again, precisely the most powerful narrative which conceal their nature as narratives. These observations, ladies and gentlemen, indicate a strong resemblance between modern concepts of development and the legal sphere. And it comes to no surprise then that the most eminent figure in the history of the concept of development, according to Kosellecks geschichtliche Grundbegriffe, was himself a lawyer. As leading figure of the so-called historical school, Friedrich Karl von Savigny was, again a quote from Koselleck, the purest embodiment of the ideals of so-called historicism. His concept of development soon became an indispensable category in all fields of study concerned with history. Savigny established a way of thinking according to which past and present events could be seen as a process. Discrete things and events were not mere accidentals anymore, but this is a quote from Savigny. It's very difficult to translate Savigny into English, but I'll do my best. But receive their intrinsic and necessary individuality from being the very essence of the whole of preceding time. Thus, whatever had been dead material matter beforehand now could be seen as the living power and industriousness of the people as a whole, the so-called Volksgeist. Historicity seemed to be literally inscribed in the reality of the present, whose destiny it was to proceed step by step to the higher grades of civilization. As it is well known, this view was taken up by many, especially historians. For them, the objectivism inherent in teachings such as Savigny's served as a means to eradicate any fictional or imaginative trace from their discourse, to avoid, in the words of Hayden White, poetical or rhetorical techniques, and to refrain from everything which might be viewed as intuitive or fictional reconstruction of reality. Aufschlussreich ist, wie Savigny Recht und Geschichte auf ein gemeinsames Lebensprinzip zurückführt. Durch die Bändigung des gleichzeitig Mannigfaltigen, Zitat Savigny, im systematischen und des sukzessiv Mannigfaltigen im historischen Verfahren wird die gesamte Geschichte im Grunde einem rechtsförmigen Prozess unterworfen. Das Gefühl innerer Notwendigkeit, das Savigny mit der Geschichte verbindet und welches allen Gedanken an zufällige und willkürliche Entstehung ausschließt, folgt, das ist meine These, der Logik des Prozesses. Dahinter steht, meine Damen und Herren, zu der Zeit, als Savigny seine Gedanken formulierte, bereits ein reflektierter Prozessbegriff, dessen Ursprünge etwa Adelung nicht mehr nur in den Rechts-, sondern auch in den Naturwissenschaften lokalisiert hatte. Aus derselben Zeit stammt Novalis' berühmtes Wort vom Zitat Generationsprozess des Urteils, des Rechts, etwas wie ein Beweis, der allgemeine Prozess, Zitat Ende, das den Prozessbegriff zum ersten Mal in die politisch-historische Sphäre rückte. Besonders ergiebig dürften auch Erkenntnisse der noch jungen Prozessrechtswissenschaft gewesen sein, wie sie namentlich Karl Ludwig Wilhelm von Grohlmann formuliert hatte. Das gilt für die organologische Vorstellung vom Prozess als Gesamtheit und Inbegriff der ihn konstituierenden Handlungen ebenso wie für das bewusste Verfügen über die Prozessgeschichte. Die Historia Processus und der Rückgriff auf frühere Verfahrensabschnitte werden nun zum Gegenstand wissenschaftlicher Reflexion mit dem Zweck rechtlicher oder tatsächlicher Erkenntnisgewinnung. Dieses von prozeduraler Eigenzeitlichkeit geprägte Denken wird bei Savigny dann zum wirkmächtigen Instrument narrativer Deutung und Gestaltung der gesamten Welt. Mittels rekursiver Modellierung der Zeit ließ sich die Rechtsgeschichte entwicklungsgeschichtlich, das heißt gleichzeitig vorwärts und rückwärts, auf ein imaginiertes Endziel hin und von ihm weg organisieren und von äußeren Einflüssen, namentlich von Politik und Gesetzgebung, befreien. Procedures, ladies and gentlemen, according to a certain view, lay the groundwork for the decisions by preparing them. By making use of the narrative of development, decisions are presented as a logical result of procedural history. That is, both legal procedure and narratives of development achieve absorption of contingency by providing a compelling temporal order of events. One might also say the narrative of development paves the way for the Derridean quantum leap from a state of indecision to the finality of the made decision being taken by, as called Cornelia Wiesmann, auto-jurisdiction. The resulting decision, that is the judgment, is lawful as opposed to unlawful, rechtmäßig im Gegensatz zu unrechtmäßig, to the extent to which it transforms the procedural development into law. As a specimen of developed history, it is also just, gerecht. As already mentioned, the development narrative's most important feature is its ability to render the narrator or decider invisible. In the functional context of the procedure, this maneuver serves as a means of increasing credibility and creating legitimacy by concealing. Moving the judge, the pivotal figure behind the curtains of the theatrical dispositif, this is again a quote by Wiesmann, into the blind spot of the proceedings, masks the scandalous sovereignty of the judicial act. We already talked about this. This ultimately serves in order to overcome the paradox at the foundations of modern law, with its origins outside the normative system, the so-called Grundnorm issue, Grundnormproblematik, quoting Hans Kelsen. Ich habe dieses Bild ausgewählt, um zu demonstrieren, dass es auf die Personalität des Richters, auf seine Persönlichkeit, das Individuum nicht ankommt. Sie sehen bei dem Foto einfach nur diese prächtigen Roben, Sie sehen nicht die Richter als Person, und das ist sozusagen kein Zufall, sondern das ist, ja, das gehört dazu, eben dieses Spiel mit der Unsichtbarkeit. Und dass Sie eben auch daran sehen, dass Richter, wenn sie tatsächlich beim Entscheiden sind, nicht beobachtet werden dürfen. Juristen haben es von und dann auch nicht präsent sind im Verhandlungsraum. Juristen haben es von alters her verstanden, den Verlust des auktorialen Erzählers als Vorteil auszumünzen. In diesem Sinne waren sie immer schon modern. Die enorme Entwicklungsdynamik der modernen Welt hat nicht wenige ihrer Vorbilder in der Selbstreferenzialität und sozialen Eigenlogik rechtlicher Kommunikation, wie sie sich seit dem Mittelalter ausdifferenziert hat. Die sukzessive Positivierung des Rechts durch Erledigung der Grundnormproblematik ist geradezu ein Paradebeispiel für Entbettung, Disembediment im Sinne von Anthony Giddens. Durch sie kurierte das Recht, könnte man vielleicht sagen, seine Weitsichtigkeit, und das Rechtssystem, das sich nun herausbildete, war zu Teilen beängstigend effizient in der verfahrensmäßigen Bewältigung seiner Aufgaben. Dadurch wurde es gleichsam kurzsichtig. In der Annahme, kulturelle Unterschiede würden sich binnen weniger Jahrzehnte global einebnen und damit schon heute keine Rolle mehr spielen, wurden, so ist jedenfalls meine Beobachtung in der Nachkriegszeit, die großen Fragen sukzessive doch eher aus dem Recht ausgeklammert. Was Rechtswissenschaft im 18. Jahrhundert, um 1900 und vor allem in der Zeit zwischen den Weltkriegen so faszinierend machte, paradigmatisch etwa im Werk Hermann Kantorowicz, all das hat die Nachkriegstheorie nicht selten nahezu vollständig beiseite gewischt. Seit dem Ende des Ost-West-Konflikts, ausgangs der 1980er Jahre und mit dem Auftauen Dahrendorf der Geschichte, lässt sich dieses Großnarrativ nach meiner Auffassung so nicht mehr halten. Seither erleben wir, wie sich der Kollektiv Singular der Geschichte auflöst und einen Schwarm von Narrativen mit unterschiedlichen Reichweiten und Laufzeiten freigibt, die in ihrem beweglichen Mit- und Gegeneinander angemessen dargestellt werden wollen. Wir sind bereits Teil dieser neuen Geschichte oder Geschichten, in denen die Frage nach der Grundnorm eine ganz neue Valenz erhält. Deshalb können Theorien des Rechts, die sie kategorisch ausblenden, ihren hegemonialen Anspruch nicht länger behaupten. Was nach meiner Auffassung Not tut, ist die Weiterung des rechtswissenschaftlichen Blicks etwa auf die Ästhetik. Hier sind Antworten zu finden auf die Fragen, die die neue Unübersichtlichkeit etwa in der post- oder globalen Diffusion des Rechts der Gegenwart stellt. Noch einmal ein Blick in die Geschichte. 1816 erschien in Savignys Zeitschrift für geschichtliche Rechtswissenschaft ein Beitrag Jakob Grimms mit dem Titel Von der Poesie im Recht, in dem er Recht und Dichtung in einen unmittelbaren Zusammenhang rückte. Beide seien narrativen Gesetzmäßigkeiten unterworfen. Zitat: In keinem ist bloße Satzung noch eitle Erfindung zu Haus. Auch sträubten sich beide gegen die funktionale Analyse. Sobald man sie zerlegen will, stößt man auf etwas, wie der Original Grimm, Gegebenes, Zugebrachtes, das man ein Außergeschichtliches nennen könnte, welches jedoch in vielfacher Weise in die Narrative hinein und zurückwirke. Mit dem Außergeschichtlichen war nichts anderes gemeint als die Grundnorm und ihr dichterisches Pendant, die Gewalt der Poesie, die in jeder Sprache das meiste vermag, wie Grimm anderswo bemerkte. Ihr beider Ursprung beruhe auf zweierlei Wesentlichen, auf dem Wunderbaren und dem Glaubreichen. Mit Wunder war dabei der mythische Gründungsakt des Rechts und des Kunstwerks angesprochen, ohne dessen transzendentale Entrückung und Verfügbarkeit, Zitat, kein Heiligtum, woran der Mensch hangen und haften soll, bestehen könne. Die Vermittlung des Heiligen wiederum geschehe durch den Glauben, wodurch es an uns gebunden wird, welcher Macht, dass es uns gehört, als ein angeborenes Erbgut, das wir wiederum behalten und unseren Nachkommen hinterlassen wollen. Zitat Ende. Grimm. Thus, 1 year after the Historical School's founding manifesto, written by Savigny, appeared in the Movement's Zeitschrift für geschichtliche Rechtswissenschaft, Jakob Grimm came forward with the outlines of an aesthetics of law, presented as a theory of inclusion. For Grimm, aesthetics did not mean mannerism or musealism in German Schöngeisterei, but science, in the words of Baumgarten, ars analogi rationis. Like his contemporaries, Grimm thought of law as organical, developed through history. Unlike Savigny, however, his interest was not so much in professional specialization and system building, but in addressing the numinous, mythical origins of law and securing their place in legal scholarship. Einbeziehung und Verstrickung, Inklusion im Recht ist bei Grimm also nicht so sehr eine Frage von Zwang, Macht oder Wissen von der Force du droit, sondern des Glaubens an das Wunder seiner Begründung, an den unerklärbaren Rest jeder Narration. Vermittelt wird dieser Glaube durch Einübung in Verfahren, in denen weniger die Folgerichtigkeit und logische Schlüssigkeit des Programms und seiner einzelnen Teile im Vordergrund steht, sondern die Überzeugungskraft des Ganzen und die Stimmigkeit seiner Form. There's something more to the legitimation of legal storytelling than trust in judicial procedures, rules of evidence and ritualization. This is a quote from Jerome Brunner. Wissenschaftlich fassen lässt sich dieses ästhetische Mehr mit einem theoretischen Instrumentarium des Recht gleichermaßen übers Eck aus der Begründungs- und der Verfahrensperspektive in den Blick nehmen kann. Durch die ästhetisierende Annäherung an Verfahren als Kunst kann das Grimmsche Außergeschichtliche des Rechts zum Geschichtlichen seines Prozesses in Bezug gesetzt werden. Damit wird, hoffe ich jedenfalls, der Weg frei für eine kritische Betrachtung des juridischen Entwicklungsnarrativs und dessen Monopolstellung im Rechtsdiskurs der Moderne. Es erweist sich dann nicht mehr, das ist jedenfalls meine Hoffnung, als alternativlos und überzeitlich, sondern als partikulare und eben dezidiert europäische Form juridischer Wahrheitsproduktion, deren Stellung im Recht der postglobalisierten Welt des 21. Jahrhunderts man vielleicht neu bestimmen sollte. Okay, now this was the first part of my lecture. Introducing to the concept of development in legal procedure and its connections to narrativity. And now I am entering into the new field of my fields of interest for the next 11 months. So, during my stay at the Käte Hamburger colleague, I would like to explore this so-called art of procedure, a vast field of interest, as you certainly notice. Let me sketch it for you in 5 short antithetic axes, representing some, in my view, promising aspects of my subject. The first of these axes focuses on the antithetic of static and dynamic perceptions of law. While the static view of law is constantly associated with concepts of text, statute, Gesetz, codes, and codification, and often linked to architectural metaphors, a dynamic perspective of law entails a broad concept of the so-called law in action. This distinction reminds one of the difference well known to lawyers of substantive law, materielles Recht, and law of procedure, Verfahrensrecht oder formelles Recht. Legal scholarship, as it is practiced at universities, perceives law mainly as a matter of textual hermeneutics. Thus, it tends to stress the static, monumental side of law, often reducing it to a mere decisionist application of written prescriptions. For most, or for many legal scholars, law of procedure is, in this view, nothing more than a servant to substantive law, which does not possess any value of its own, besides enabling the latter to function most effectively. Also Verfahrensrecht als dienendes Recht, also dem materiellen Recht dienendes Recht. Law, as understood by many scholars in the legal field is this perception about interpretation, not so much about performance and performativity. In the view presented here, procedure means much more than pure application of textual rules. Contrary to the prevailing notions of many academic lawyers and sociologists, and Because of its non-interpretative, performative traits, it cannot be reduced to the mere preparing of decisions. It comes as no surprise then that among the biggest advocates of procedure as being linked to drama, theater, dance, and even music on one side, and liturgy and religious ritual on the others, are attorneys and other practitioners of law. The following statement is from the Californian trial lawyer Rafael Jodos. Quote, "For the fact is that substantive law requires application and has to unfold. And therefore we require procedural law that deals with the process of unfolding. Centuries of legal disputations have taught us that it is not possible to understand law as a static construct. Ancient images of the law as a temple, which stands fixed and immutable throughout eternity, and into which we enter in awe as we seek to discern its architecture, those images must be relatively late romantic conceits. They may perhaps be understood as fanciful elaborations of the familiar images of the columns and steels on which early codes were often inscribed. The notion of writing a set of law on a stone surface may be very old, but the conception of the law itself as a physical temple probably came or comes much later." Quote end. Before I turn to my second axis, which is about invisibility and visibility of the judge or narrator, I'd like to draw your attention to this beautiful sketching, which in my view represents well the antithetic of static and dynamic law, because what you see here is a dancer, right? This is a system, a costume de ballet, and what you can see here is a dancer with static paraphernalia, right? You see circle compasses here. Right? This is the roi géomètre. It's the absolute favorite picture of my presentation tonight. So. If you don't take anything else from this lecture, please take the roi géomètre. Okay. My second axis deals with the antithetic of invisibility versus visibility of the decider-narrator figure. Among the oldest narratives of law are images of a trial process in which a divine being sits in judgment over a soul. So we have the haunting image of the weighing of the soul in the Egyptian books of the dead. In the Papyrus of Ani, for instance, which dates back about 1300 before Christ, but which relies on a much older religious tradition, we see that there are rituals where the soul must perform as it leaves this world and goes towards the throne of Osiris, where it will be judged to see if it is worthy to spend eternity in Lightland. In the Papyrus of Ani, there is a picture of the trial of the soul. It shows the human figure, tiny in the presence of the gods. Osiris is sitting on the throne, and Anubis, with the head of a dog, is presiding over the weighing of the soul of the deceased. This weighing process is terrifying because the soul is on one side of a balance scale, and on the other side is a feather of truth, Maat. And if the dust and other baggage which the soul accumulated in the earthly life weighs down too heavily, if it weighs more than the delicate feather, then the scale will tip against it. And this is what the sharp eye of Anubis is checking for. As you can see from this picture, the judges in this Egyptian trial of the dead are present during the act of adjudicating, with Anubis watching over the scale and the others sitting by. The room in which the decision takes place is constituted by the judges in persona. The essence of law, we may then infer, again quoting Horace, was not originally the courtroom or the institution where the trial took place, but it was rather the trial procedure itself which unfolded in this courtroom. This ancient description, ladies and gentlemen, contradicts the Occidental model of the trial with its king-like judge with regal attire and its economy of invisibility, where judicial decision-making takes place behind curtains and must not be observed neither by the parties nor the public. Our model, then, seems neither to be universal nor without alternatives. According to a tentative hypothesis of mine, legal cultures with monotheistic belief systems prefer theatrical patterns of changing invisibilities and visibilities, whereas polytheistic cultures may favor the tribunal. In the coming months, I would like to look at this question, studying other ancient and contemporary trial forms, among them, of course, the famous judicium of the Roman civil law. My third axis deals with the relationship of exclusion versus inclusion. An obvious feature of trials is the measuring of the spatial and social distances between the participants on the scene and its onlookers. As in Greek tragedy, there are narrative patterns of interrelation which must be reenacted again and again in order for the play to succeed. A view of the trial process as a mere preparation of decision does not, in my view, sufficiently explain these requirements of entanglement, Verstrickung, and personal involvement. The notion of procedure founded solely on rationalization, professionalization, and social and functional differentiation misses, in my view, these central aspects. It must be completed at least by an aesthetical approach which would not only pay tribute to the value of procedure in itself, but also may alter our understanding of its ultimate goal. According to established beliefs, the trial's only goal worthy of achievement is, said that already, the court decision. Its opposite, the party settlement, is viewed as something out of place, or at least undesirable. Just think of the debate on plea bargaining, deals in penal procedure, as it is called in Germany, or the general unfavorable view taken on alternative dispute resolution, ADR, in civil procedure. According to legal aesthetics, however, both the deal and ADR have one great advantage, and this is the advantage of entanglement and inclusion, whereas the court decision excludes at least one of the parties, the one that lost the trial, with necessity. The latter's claims are in German aus dem Recht gewiesen, literally expelled from the law. The result is its losing trust in the law, possibly, and losing faith with respect to its adversary and the onlookers. Why not then redirect scholarly interest in procedural matters for a second away from its fixation on decision-making and effectivity towards the specific benefits of non-deciding? My fourth axis looks at the foundations of law by pitching art and the force of law against each other. To see decisions as the point of decision-making is to see orgasms as the point of love-making. The author of this remark, social psychologist Daniel A. Newark from Stanford, hints to a side of procedure which so far has not been very much present in legal discourse. In a new essay, he praises indecision as a constructive space where we, quote, clarify our beliefs and values and see how they fit with those of the people around us. What do I really want here? What is the choice to be made actually about? What am I afraid of? And so on, quote end. These questions indicate a close connections between indecision, the state of indecision, and questions of identity. Indecision, goes the argument, allows us to discover or affirm who we are without us even realizing it because we are so much concerned with making the decision. This, of course, is true not only in personal or business decisions, but literally cuts to the bone of legal procedure. I am reminded of a story which happened to a friend of ours who is an attorney specializing in labor law. A characteristic of this type of procedure is the compulsory conciliatory hearing before the judge who will have to decide the case, the so-called Güteverhandlung. Pleading before the assize court in the beautiful city of Worms, which at the time was presided by my husband, he told us, our friend, the attorney, told us how surprised he was when his client, who had always declined any sort of conciliatory solution, suddenly became amenable to the very same solution he, the attorney, our friend, had already been suggesting to him for quite a while. Our friend marveled at the magic of procedure, which had just taken place in the constructive space opened by the judge, who, by playing the harp of indecision, and like a gifted narrator, hinting at the several possible outcomes of the trial, had set in place an atmosphere of creative ambiguity. Pitching our friend's client's claims against the one of his adversary, making him think of moral hazard, he had not only induced him to make up his mind, but reminded him of his better self. By the means of narration, something new and unexpected had been introduced into the proceedings, the possibility of reconciliation. But to what do we owe this unexpected newness? The common answer to this question of the origins of the force of law is, of course, power, and a very special power at that. It is Gesetz, the normative imposition of a superior will. But does this really explain, ladies and gentlemen, what did just happen before the assize court in Worms? While it is true that the court proceedings are thoroughly saturated with the paraphernalia of power, the story seems to hint, in my view, at something else. Grimm's Gewalt der Poesie, perhaps, or what Werner Gebhardt at our last fellow meeting called the aesthetics of ambiguity, the beauty and the thrill of carefully crafted indecision. Like an experienced dancing master teaches his pupils new steps, carefully observing and correcting their movements with respect to each other and their surroundings, conciliatory efforts by judges can enable the parties to find solutions which outside the proceedings seemed utterly impossible. Let me conclude, ladies and gentlemen, with a few remarks on the topic of development and evolvement. So evolution and versus imitation would be the last axis I would like to address in the following months. How does legal change come about if we view law not so much driven by force for a moment, but by narration? Another case story, this time not situated in Worms, but in an oriental surrounding, goes like this, as it's narrated by Gunther Teubner. An old wealthy Bedouin sheikh wrote his will and divided his fortune, a large herd of camels, among his 3 sons. Ahmed, the eldest son, was to inherit the first half of the fortune. Ali, the second son, should get a 4th, Benjamin, the youngest, a 6th. When the father died, unfortunately, only 11 camels were remaining. Ahmed, of course, demanded 6 of them and was at once contested by his brothers. Finally, when everything broke down, they turned to the Qadi. He decided, I offer you 1 of my camels, return it to me, Allah willing, as soon as possible. Now, with 12 camels, the division was easy. Ahmed got his half, 6 camels. Ali got a 4th, 3 camels. Benjamin a 6th, 2 camels. And indeed, the 12th camel was left over, which they kept and fed very well, and happily returned to the Qadi. Of course, you know this story. There has been quite a discussion some time ago about the origin of the 12th camel as the surplus law brings into the world. Can it really be made up as a product of evolutionary development, as contemporary theory has it? Then where is the varying, where the selecting? Here's an alternative culturalist reading. Introducing an additional camel into the process of dividing does not amount so much to evolution, but to imitation, sociological concept brought up by Gabriel de Tart more than 100 years ago. Its creative potential is not in any way inferior to the one of Darwinist evolution. Contrary to the latter, however, it pays tribute to the vast narrative spaces between variations and selections, the place of art. Creating the 12th camel is dealing with this hitherto widely unexplored dimension, the aesthetics of procedure. So, ladies and gentlemen, let us dance with camels. Thank you so much for your kind attention.